live at 8. The highest court in the land ruled today that owners of videotape recorders can indeed tape movies or other TV programs for private use without breaking the law. TV5's Steve Craig explains what today's Supreme Court ruling means.
Long before Dallas and theatrical movies, Lorimar Productions made its money on Walton's Mountain. Now, a decade later, the residuals are still flowing in from stations including TV5 that rerun the reruns. Lorimar and other producers contend that home taping makes such programs less valuable. But the Supreme Court disagrees, saying that home taping for private use is okay. Those in the booming video industry can't understand what Hollywood is hollering about. Eric Martin says video is simply another outlet for the movie makers.
Biggest one going now is Raiders of the Lost Ark, which came down to $39, which has been a very good seller on that. And the studios are getting $5 a roll on each tape.
Buying or renting movies and then duplicating them for friends is illegal, but that takes 2 VCRs.
Hollywood wants to tack a $10 royalty fee onto the purchase price of each and every blank cassette that is sold. That way, they say, they'd get their fair share of the profits. But would it be fair to pay $10 extra for this cassette if it were used, say, with this camera to videotape your daughter's wedding?
$1 a tape has also been mentioned, as has $50 to $100 per VCR sold. Martin says any markup would simply create a black market for those products. Right now, it appears that TV advertisers have the most to lose from the new technology. Many VCRs allow viewers to rapidly skip through the commercials in pre-recorded shows. What effect that zapping, as it's called, is having on those who paid the bills for over-the-air TV isn't yet clear. Steve Craig, TV5 Eyewitness News.
The industry says it will fight a U.S. Supreme Court ruling allowing Americans to videotape TV shows and movies for their personal use. CNN's Sandy Kenyon has more.
It was a clear victory for the young video recorder industry in general and the Sony Corporation in particular. In New York, its president, Kenji Tamiya, hailed what he called the Supreme Court's landmark decision.
Like I said, this is a long and a difficult battle, but we are very gratified that the Supreme Court made a decision in favor of Sony and at the same time in favor of the consumer.
You think it's over?
It's over.
You think the fight is over?
It's over as far as the Sony Betamax case is concerned.
No, it's not over, say the motion picture companies. In fact, their representative, Jack Valenti, claimed the battle has barely begun.
Nobody, but nobody wants to halt new inventions. Nobody wants to put up a barrier against new technology. But the whole essence, the heart and blood and sinew of this issue is this. Whenever a new technology enters the marketplace from whatever source, it is the obligation of the Congress to define clearly and precisely the rights of copyright owners.
The movie studios want protection in the form of a tax on the sale of blank cassettes and video recorders. Those royalties would go to the studios and the performers. The results for the consumer would be higher prices. Congress has yet to act on that request, and the video industry strongly opposes it. For now, the plaintiffs in this case, Universal Studios and Walt Disney Studios, were not available for comment. But it's clear the movie industry plans to continue its fight in the courts and in Congress to determine what Americans may tape and how much they should pay for that privilege. Sandy Kenyon, CNN, Los Angeles.
The wife of former...
From ABC News, this is World News This Morning for Wednesday, January 18th, 1984. It's 6:30 a.m. Now from our Washington news desk, Steve Bell and Hillary Brown, sitting in for Kathleen Sullivan.
Good morning. The motion picture industry says the home videotape battle is not over. A divided Supreme Court ruled yesterday that Americans are not breaking the law when they tape TV shows on home recorders. But as Judd Rose reports, Hollywood is turning now toward Capitol Hill.
This is Judd Rose in Los Angeles. The Supreme Court's decision is the latest but not the last round in one of Hollywood's hottest battles.
Would you care to step outside?
Superman!
The losers, the studios that spend millions to make films like these. The winners, those at home who can copy them at no cost with the push of a button. The movie makers say they should be paid for the privilege, otherwise it's video piracy.
You cannot have high-class entertainment if 50 million taping machines are out there
in an unauthorized fashion with no compensation to owners, taking from them what rightfully belongs to them.
The home recording industry is big business. Sales of recorders and tapes total more than $2 billion, and the studios have vowed to get their share of the profits.
They've told me that they've been around for a long time in the past. They'll be around for a long time in the future. If they don't win today's case, they'll try again somewhere else, some other time, but they'll keep trying till they get what they want.
Already, legislation has been introduced on Capitol Hill that would impose a royalty on the use of home recorders, but many in Congress express doubt it will be approved. So while millions continue to record their favorite shows, Hollywood goes from the court to the Capitol in its effort to say,
"Would you get going, you pirates?"
Judd Rose, ABC News, Los Angeles.
This evening news, Dan Rather reporting. The Supreme Court today answered a multi-billion-dollar business question affecting the wallets of millions of growing forms of recreation, home videotaping. The court ruled 5-4 that use of the home machine to tape programs is legal and violates no copyright law. But it may be up to Congress to record the last word on this subject. Law correspondent Fred Graham reports on the High Court, high-tech, high-stakes decision.
Here we go, very quiet, and we are rolling.
The losers are the makers of TV programs and movies shown on television who claim their films lose their rerun value when they're recorded on home videotape recorders and then played later. The movie studios said this violated the copyright laws, and they sued the home recorder manufacturers for allegedly instigating widespread in-the-home lawbreaking. But the Supreme Court held that when people record TV programs at home for personal use, this is not a violation of the copyright laws. The Sony Corporation reaction, all smile.
We fought this case for entire home electronics industry as well as consumer. And answer your question, I hope that this will help us.
We've always said, Hollywood, welcome to this great new technology. You would have liked an injunction on television. They would have liked an injunction on cable. They would have liked an injunction on the video cassette recorder. But they didn't get it.
The movie industry now says the Supreme Court was only the first step, and they'll launch a high-voltage lobbying campaign in Congress for changes in the copyright law to compensate them for all that home videotaping.
You cannot have high-class entertainment if 50 million taping machines are out there in an unauthorized fashion with no compensation to owners, taking from them what rightfully belongs to them.
If Congress should overturn the court's decision, it would probably mean that consumers would pay an additional fee whenever they purchased a new videotape recorder or a blank tape, which hardly makes the idea seem an attractive issue in an election year. Fred Graham, CBS News, Washington.
Two other noteworthy Supreme Court rulings in one.